So this is yes, and the dog. This is what week are we up to? Week 6 of succession law, and got a few things to talk about tonight. The first thing is we've just had a break, the mid-semester break, and we've got 3 weeks before the Christmas break. Part of things I guess we'll have to resolve tonight is the third week, which is week 6, 7, week 8, falls on the 24th of December. So I thought I'd take a quick poll as to how excited you guys were about having a class on Christmas Eve. We've got plenty of time at the end of the semester to skip that one if you would prefer. So unless I hear a resounding no, please, let's go ahead. We've got nothing better to do on Christmas Eve than talk about succession law. And if you feel that way, I'm quite happy to run it. But I'm suspecting we won't have a whole lot of attendance on that night. So I imagine most people have something to do on Christmas Eve. So we're in a weird position now. We've just got two weeks, and then we've got another break, and then we start again, which is making it a little erratic at the moment. Now, in terms of the coursework for this week and the reading, we're on week 7, chapter 7, of the text, which I will talk about very, very briefly. But honestly, it's a short chapter and there's not very much in it, and it's not all that useful. But if you have questions about it, it's a good time to ask them, I guess. So it's the chapter on republication and revival, and that's where you have a dead will and you want to bring it back to life. And basically, you have the same evidentiary and execution onus as you do with any other will, but you can basically say, I want to revive that will that I had terminated earlier on. When would you do this? The simple answer is you wouldn't. If you had a client who wanted to go back to an earlier version of the will, given that you have to execute the thing again, you just start again with a new will. You wouldn't go and use any of these rules. So again, a lot of succession law is like this, and in fact, a lot of law is like this. If you just focus on cases, they're all the sort of bizarre weirdo situations where some case happened in 1843. And this really bizarre thing happened, and it went all the way through the courts, and the court said, we want to look at this, this is really weird, and they came to a ruling. It has very little bearing on actual practice. I know I find it particularly frustrating, and I'm certainly not going to set an exam question on this stuff. So yeah, if you've got questions about that chapter, we can deal with them now. I'm just having a quick flick to see if there was anything I made note of that was relevant. Oh, yeah, there is one thing. If it does happen, ever happens in your career, and if it does happen, please find me and send me an email, because I would be amazed. When you republish, it republishes the codicils as well. And the example they give in the book is if you leave money to 3 people, and then you publish a codicil that says, I'm taking back one of those gifts and I'm not gifting it to that person, and then the will gets you terminate the will, and then you republish it, it doesn't republish the very original one. It republishes the will and the codicil that modified it. So again, I think you'd think that makes sense, and I think that would be the thing that you would figure if it went to court, that's what they would do. But hey, there was a case, people argued about it. Alrighty. and it is literally a very small number of pages. So we can leave that aside, I think. There was a couple of other things I wanted to cover in the course, and rather than move around the chapters that the previous person has said, I thought this would be a good week to cover a couple of those things if we've got a bit of breathing room to fit them in. So one of the things is I want to talk about is power of attorney, powers of attorney, and the other thing is the subject of the workshop this week, which is the issue of mental health and legal professionals, which is a significant issue. So I'll cover the powers of attorney question first. This is something which I asked you folks about earlier on, whether it was covered somewhere else in the course. And I can't even remember where it was covered. I think it was covered in equity when I studied, but it's all statutory now, so maybe it doesn't belong in equity anymore. Powers of attorney are basically the situations where you want to hand your decision-making power over to someone else, either because you're not going to be able to deal with your affairs for a while, and that's your classic power of attorney was someone who went away on holidays and they wanted someone to be able to collect the rents on their property or pay rents or pay bills and do those things. And you create a power of attorney which would delegate that responsibility to that person or people to carry on your business for you. The other situations where you want to create a power of attorney is where you fear you're going to lose capacity and ability to make decisions for yourself. Obviously, this type of power of attorney has much more in common with succession law. The previous one is probably, I don't know, where you'd cover it, contract law maybe. It sort of is an odd one out at the moment. The other forms, which we call enduring powers, are ones where you fear that you are going to lose capacity. Now, under the common law, or under the non-statutory scheme, because I think it was equity, hi Jeff. You could only assign power under a power of attorney that you actually had yourself, and if you lost capacity, then the person who had the delegated power also lost capacity. So obviously that wasn't much use for people who were said, if I lose capacity and suffer from dementia, I want this person to take over from me, because under the original forms of the powers, it terminated as soon as you lost capacity. The other forms of powers that people like to use are what are sometimes called living wills, which is where you want to give someone the responsibility to say, if I can't make medical decisions for myself, I want to hand that power over to someone else to make those decisions. I don't want a doctor, for instance, to put me on life support when I don't have any brain function and that sort of thing. Okay, and again, that was a problem under the original doctrine, because the person you delegated the power to would only have the power that you had, which would be no power at that particular time. So we've, under statute, created these things called enduring powers, and all the states are slightly different, just to make us really crazy. And you'll have to have a bit of a look at your own state's provisions. At the moment, I'll dig out the guides from the other states, but I've put up on the main section of Moodle, right at the top, the Victorian guide. Not because I think the Victorian law is better than anything else, but I think the guide is better than anything else. So I think it's a good starting point. Later on, I'll go and dig out New South Wales and Queensland to see what they have. But their guides weren't as informative. The other thing to make this completely more complicated is that all these areas are I think in all the jurisdictions, they're under review at the moment because they are slightly problematic. Why are they problematic? Because we have basically 4 different types of power of attorney. There's the old-fashioned style, which we still call a power of attorney, or a general power of attorney. There's 3 enduring powers. There's enduring power of attorney financial, enduring power of attorney medical treatment, and enduring power of guardianship. How are these different? Well, the financial one obviously is ability to make financial decisions. Medical treatment one is going to be medical treatment as well. And the one that's not as intuitive is guardianship. And what they talk about there is lifestyle issues. And that's basically looking after someone and making all those day-to-day issues. And the guide's quite good at distinguishing these and talks about where someone is medically ill and can't take care of themselves. An enduring power of attorney medical treatment would allow you to decide if that person had to have an operation and whether or not to have that operation. The guardianship would let you make decisions about the person's diet and their general health and where they lived and those sorts of things. So they kind of overlap to some degree. It's just my phone, I'll deal with later. They kind of overlap to some degree. The problem with them is if you want all these things, you've got to execute 3 different documents. They're all separate and independent. And I suspect what the law reform process will result in, who knows how long this will take, will be a way of ticking the boxes and being able to have one document where you can tick one of those 3 things. So remember, the 4th one is the general power, which is I'm going on holidays and I want someone to take care of my business. The other 3, the enduring ones, are all the ones where you lack capacity. And they overlap quite a bit because when you create your will, you also would want to be wanting to think about how do I arrange the will is what happens to my affairs when I die. The enduring powers are what happens to my affairs if I don't die, but I'm no longer able to make decisions on my behalf. And the guide that I've linked up there, I didn't want to go crazy and put too much information up there for you. It's good. In fact, it's better than most legal textbooks because it's actually got standard forms for all of them. So it's really worth having a look at those forms. But it also gets across that for your average punter, it's quite a daunting prospect to be able to execute these basically 3 documents. What else do we need? What else do we need to know about them? They're the sort of things that people who go in for wills will probably ask about. They may affect a will because if you have a financial enduring power, you may be selling property. So someone may say, leave their house to someone in the will. They become unable to take care of themselves and have to be put into a nursing facility. The family house gets sold to take care of to pay for the nursing facility. The gift of that house under the will then be invalid. Now, the person who got the house may get the remainder of the money after the nursing home's had it, just under the general provisions of the will, or they might not. So the person who has enduring power doesn't really have the power to actually change the will as such, but they're going to be able to make decisions that may dispose of property that would ordinarily be there under the will, which may mean that we're going to look at next week or the week after what happens when you give someone something under a will and you don't have it anymore, which is it's unusually practical for this subject. You'd be in that sort of circumstance if you had someone who was using their enduring powers to make those kinds of decisions. And that's the kind of things that they generally have to do. Generally, when people become that ill that they can't make decisions for themselves, it's usually the family property that has to be sold in order to take care of them. And Louise is saying, is it just in Queensland the power of attorney for health issues is called Advanced Health Directive? It may well be, and I'll have a bit of a look into this over the next couple of weeks.
Are you there? Sorry, Scott.
Yeah.
I actually work in succession law. It is an Advanced Health Directive here in Queensland. And with your enduring powers of attorney, you can do your financial and your personal health ones in a joint document as well, or you can do them separately if you want to appoint separate attorneys for financial matters and then a separate attorney for personal health, which is your day-to-day management issues.
Okay. If you know of a good guide, I can put the link up for. That'll save me digging it out.
Yeah, I can have a bit of a look for you.
Yeah, send me
The other thing with the Advanced Health Directive as well is you actually need to complete that with your doctor to be fully informed of what decisions you make medically. So that has to be signed off by a doctor. Then you go back to a JP or solicitor and have it witnessed. And the specification for a JP with that one is they actually have to be over the age of 21 years, not 18 years as well, for an Advanced Health Directive.
I love this stuff. I mean, when you start lining these things up across all the jurisdictions in Australia, you can see how much there's a need for a uniform set of legislation across the board. And I think that's what we're aiming for at the moment.
Yeah. And the other thing too with your powers of attorney, if you're dealing with real property, you do actually have to have them registered in the titles registry before the attorney goes and signs any property dealings and stuff like that.
Okay. Cool. So yeah, we'll collect some more documents and stick them up there. Like this isn't stuff that's going to be on the exam because it's not in the syllabus, but it's probably stuff that's really useful for everyone to know. Not in a read through, memorize, and know section numbers kind of way of knowing, but in that more general kind of. It has to be locked away there somewhere. So at some point when you hit it in practice, you go, oh, okay, remember we talked about that in Succession way back, I'll look up where it is. And by the time you come to practice, I'm thinking and probably hoping that, that there'll be a uniform scheme across Australia, and that will make things a lot easier. I think the hold up has been this kind of edges onto the edge of euthanasia. And euthanasia is a very, very hot political potato. And I think for most people, the idea of the power of attorney in relation to health issues is reasonable. But then there's a number of people who'll go, but what happens if the moment I suffer from dementia, my family decide to turn my life support off? And have me euthanized and all these sorts of things. And obviously you can't do that under the power of attorney. And I mean, I'm guessing you can't do that under the health directive either. You can't euthanize an elderly relative. But the problem is as soon as you start moving into this area of law reform, you get the fringe interests and you get people saying, no, we can't have this and agitating and so on and so forth. So, I think the law reform stuff seems to have been keeping a really low profile, and that's probably why, because they are wary of the, I suppose lunatic's probably a pejorative term to use, but that kind of lunatic thing that happens when you start dealing with health and disability issues, and people start immediately saying, it's going to be euthanasia and all the old people are going to be put to sleep. Anyway. We're not dealing with that. At the very most, what we're dealing with is someone who is in a position where they can't make a decision to be taken off of life support, and someone else has to make that wonderful decision on their behalf. I'm sure that's a very difficult decision for anyone to make. In any case. Okay, so I will put some more material up as we go on powers of attorney. And if I can find out what the progress is on the law reform, I'll put some notes up on that as well. As I said, it's not going to be on the exam. However, if you do think an exam or one of the workshop topics or even your assignment, there's parts of it that's going to touch on that, by all means, include this stuff as well. All right. Now, this week's workshop, let me find the page, has the rather grim-sounding title of Trauma and Legal Professionalism. And I don't want this to be necessarily a grim topic, but it's one that as a school we are ethically obliged to include. And in fact, we're at the present moment going through the accreditation process of getting our school accredited with the Council of Australian Law Deans. And one of the things they require us to do is deal with mental health issues in legal professionals and with law students. So this is my small contribution to that. We're going to have to do something grander across the law program, so you'll be seeing this again. But this is just my first attempt to try and make sure we raise consciousness of some of those issues. Okay, so what are the issues? There has been, unfortunately, something of an epidemic of suicide and mental illness and substance abuse amongst lawyers. And it's something that has come to our attention recently. It's one of those things that's been a secret in the profession for a long while, and people have not necessarily actively covered up, but they've certainly sort of papered over and ignored the issue because people don't really like talking about mental illness, and they certainly don't like talking about suicide. So it's been with us for a while, but it's been one of those things that people have had tragic accidents and whatever, and people have not spoken about the reason they've died. The reason I want to talk about it in terms of succession is that succession, as we've mentioned earlier, is one of the sort of in one way, I think it's one of the gloomiest areas of practice, because it's dealing with death. It's dealing with a situation where your client does not have an optimal solution at the end of the day, because your client is going to be dead. I think that's this is it's a matter of how you perceive it, though. And I also think there's a way of looking at succession as being a very important part of people's lives, and being able to help people sort out their affairs and being able to give them certainty with what's going to happen when they're gone, I think is a very positive thing. So I think necessarily saying that this area is an area that's going to be a high risk area because it's traumatic, because it deals with death, is a bit like saying that undertakers must be terribly gloomy people because funeral directors and things must be gloomy people because funerals are a sad thing. I think it requires the right way of thinking about it, and the right way of looking at what you do, and the right way of judging success. So there. I figured, since we had a light week on the chapters of the textbook, we spent a little bit of time talking about it, and a little bit of time talking about what we can do about some of the problems. So, what are the problems? There's lots of statistics floating around, but some of the more reliable research that's been done has suggested that 1 in 4, I think, legal professionals will attempt suicide at some point in their career. And that is a lot. That is a very, very high amount. They also show that people going into law school don't suffer any sort of, before they go into law school, they don't have a higher chance of mental illness. But as soon as they're in first year in law school, the incidence of mental illness increases. So any argument that we could have that it's just like the kind of person who wants to study law, like you've got to be mad to study law sort of argument, isn't true either. Okay, so is it the subject matter? Is it because law basically deals with conflict, and basically law is about the horrible things that happen in people's lives? Well, medicine also deals with the terrible things that happen in people's lives, and there isn't the same jump in suicide amongst doctors. And you think, when it comes to stressful jobs and stressful work, telling people they're suffering from a debilitating illness or they're going to die, I would think would be much more stressful than anything we deal with legal professionals. So the open question, and we've got a bit of research into this, is why? Why is it? What happens in law? What are we doing to people in law school? And how do we stop doing that? Are we doing something wrong in the way we teach? Are we doing something wrong in the subject matter? One of the arguments is that law trains you to be a pessimist and to see everything in terms of the conflicts that could arise and the problems that could occur. So if someone says you're getting married and your law brain starts going through, dissolution of marriage. Most marriages don't last more than 2 years, or 40% of marriages don't last more than 2 years. Go through the family law in the back of your brain in terms of what happens there. Someone is starting a new business. Your law brain says, okay, you've always got to think about insolvency. What happens when you go bankrupt? So there's a small amount of truth in that, and it's a bit of discussion on I guess it's that mental disposition thing again, and it's sort of, I mentioned that. Ooh, someone. When we talk about succession, you could look at succession as being the most awful area of law, if you liked. That it's all about death and horrible dementia and incapacity and these terrible things that happen to people. Or you could look at how important it is to be a professional that helps people through these processes. And I think that's how doctors avoid the same mental illness. I think doctors have a very strong sense of what it is to be a doctor and to help people. And with lawyers, we don't really talk about that as much as we should. And we don't really, when we talk about legal ethics, we talk about, you don't steal money from your clients and you don't do those sorts of things. But we don't think about what are the positive ethical parts of being a lawyer. What is it to be an impartial advisor? What is it to be someone who helps people make the right sorts of decisions? So, in terms of the further reading for this week, if you wanted to look a little further for your, you wanted to do the workshop, the quiz thing on this week, there's the Tristan Jepson Memorial Foundation that I've included the link to. Tristan was a young up-and-coming lawyer who killed himself a couple of years ago, to the great shock of everyone who knew him. Unfortunately, he's one of many. And the foundation and our school is a signatory. Hopefully, we'll be becoming a signatory to the foundation, along with many other law schools. We're really committed to doing something within the program and making changes. Part of the problem is we just don't know yet what those changes are. But part of it, I think, is bringing these issues into the open and talking to people about what their options are. In terms of seeking help. So certainly as students, you have access to help within the university. The university has counselling services, whatever, but you also have help within the school. So Stephen Colbrand and myself are both senior staff, and we're both very happy to talk to students about any issues they're having and to help you out. As much as we can. We're not counsellors, we're not trained therapists or anything else, but certainly if you find that you're struggling and you want someone to talk to and talk through problems, we are available for that as well. We'd also like to build the student network a bit more strongly too. It's difficult with a distance course. In a face-to-face law school, of course, we'd have barbecues and sort of social events and things to get everyone together, to try and keep everyone connected. It's kind of difficult with an online course. And again, if anyone's got brilliant ideas and they say, what I really think we could do with is X, let me know and we'll arrange something. And we at the moment got running through some of our options in terms of how we can make those social connections more relevant in the school. Okay, I realise this is a kind of a difficult topic to discuss, but I'm certainly, if you've got things to say, don't hold back. One of the things that's useful in the Jepson Foundation is guidelines for legal practice, and there's guidelines around things like life-work balance and maintaining well-being within an organisation. And again, this is something that in the past firms and organisations just didn't really see as part of their business. They just thought that, we pay you, you come to work, you do as much overtime as you can before you keel over, and that's where our responsibility ends. The firms that are signing up, and there's quite a few that are signing up to the Jepson Foundation, are saying, no, we're going to be proactive about trying to make sure people are getting, taking proper leave and have working proper hours as well. My take on it, as simple and maybe as ineffectual as it is that we need to talk more about the good things about being a lawyer. We need to respond less to people. We need to respond more and more actively to people who, talk about lawyers all being sharks and cheats and ripping people off. We need to be sort of clearer about what our profession does and how important our profession is. And again, it's that there's another aspect of the research where they suggest one of the causes of depression, certainly, I'm not sure about anxiety, is that one of the benefits of being a lawyer, that seems to be a benefit of being a lawyer when you're outside of the picture, is the salary. And there's a perception in the community that lawyers earn a lot of money. I can see Megan shaking her head. Anyone who knows lawyers, and again, there's been statistical work on this done. Lawyers don't make all that much money. Some lawyers make a lot of money, but you could say that about musicians too. You could say, oh well, the Rolling Stones make millions of dollars, therefore every person who has a guitar is obviously earning a lot of money. And I think what we find is that the average starting salary within, I think, 10 years of being a lawyer, you're better off being a dentist by a long way, and you're actually probably better off being an electrician or a plumber by a long way as well. The salaries for lawyers aren't great, and even if there were, there's a point where there's a so what to that as well. Like, even if we were earning stacks and stacks of money, if you don't have, it's just the barristers that make. I'm not even sure the barristers make that much money because they don't appear in court that often. They make money in very concentrated little spurts when they're appearing, and I think barristers sometimes end up even worse off than people in firms because they're grabbing all the business they can get, and they're the ones who are supposed to be looking after themselves, and they don't do a very good job of that very often. So I think all the money's actually in senior partners in big firms, and weirdly enough, they're becoming less likely to be lawyers. They're more likely to be kind of more people who are more accountants than anything else, because the law firms are all diversifying and they're turning into these big kind of global accounting, human resourcing kind of monoliths. So the people who are making the big money are probably going to be marketing and human resources people, not the lawyers. So yeah, at the end of the day, even if you were earning a lot of money, if you weren't happy in your job, that's not going to actually help you. And it's not going to help you with the mental illness thing. Because, someone once said money doesn't buy happiness, which is probably true. Although David Lee Roth said money buys you a boat big enough to sail right alongside happiness. And I'm probably showing my age because you guys probably don't know who David Lee Roth is. But he was the singer of Van Halen back in the 1980s. And he had a lot of money. But being facetious aside, there is an issue with which if your lifestyle is out of kilter, and even if you're earning a lot of money, that's not necessarily a good thing. It's not making you happy, and we've also got then those tight issues of drug dependency that are escalating some of these problems as well. So alcohol and illegal drug abuse is big within the legal profession. So the danger of all this is that by talking about this, I'm just making everyone more depressed. And this is kind of labeling theory in action, where I just say, your future is doomed. You're going to end up depressed and anxious and sad and have a terrible life. And it's not what I'm saying at all. Lots of lawyers who know what they're doing and have a very clear idea of what their role is, I think have very good lives. And and I think it's probably in the small firms, and some of you are working in small firms and working with small practitioners, you probably have a better chance of being able to see those good things and being able to see the difference you're making. You'll be able to see the situations where people come in distraught, in trouble, needing help, and you can help them out. You know, there's criminal cases. People need, or people are being sued. They go to us to ask for help, and we provide a steady anchor to help them out and to guide them through the process. So I think we need a bit of kind of lawyer pride in what we do. And we need to sort of hold back against the sort of people who bitch and complain about how much money we make, because your electrician's probably making more than us, and you don't hear people. I haven't heard that many electrician jokes. I've heard lots of lawyer jokes, haven't heard many electrician jokes. And we study, for a long time to get to the point that we do that. So I think I don't think the profession's perfect by any means. And I think there's definitely people around who are kind of earning the bad reputation for everyone else. But most of the lawyers I know are hardworking, thoughtful, decent people. Okay. So in terms of the workshop for this week, I don't know if anyone is wanting to do the quiz or not. This is probably a good one to think about doing. I would have a look at the resources on the Jepson website. I particularly like its focus on positive well-being. I don't know where we're going from this. I don't know. It would seem a little artificial to have like a core course in the law degree, which is positive well-being for lawyers. You know what I mean? If we had someone from the Sunshine Brigade come in and we do a whole unit of study on being happy, I think I would hate that. Maybe it's because I'm on the law. I'm part of the problem rather than the solution. But I do think that we will see more in the curriculum. Resilience. Jeff just said resilience is now compulsory in the PLT. Yeah, resilience is a really, really weird thing. It's become a big business discourse. And part of it's really good and it's about well-being, but part of it's a kind of blaming the victim thing too. I've heard, I went to a business breakfast talk with our VC of the previous institution I was at. And basically all they talked about is how young people have no resilience because they're all spoiled. And basically we have to teach them to be tougher because young people leave work just because they're, earning miserable rates and don't have any time off, and then they just leave jobs. And basically you've got to, so there's a real backhand part of the resilience discourse. There's certainly a really weird reactionary group within who talk about resilience, who are talking about something different to what everyone else is. So yeah, I think that's great that if the PLT actually has a component in there that talks about it, as long as they're not just sort of blaming people who are being exploited for their own situation.
No, Scott, we've had to do whole workshops on the basically the Jepson Memorial and all of that sort of stuff, and basically just health and well-being, and go through the whole process of what causes the issues, and time. Time cost billing is a big issue that places pressure, and work-life balance and all that sort of stuff. So it's they are trying to focus on it. So they're actually a working partner in the Tristan Jepson Memorial process, I think, in the foundation. That's through the College of Law that I'm doing.
Okay. Yeah, it's such early days. I mean, everyone's basically who's kind of decent is signing up to it, but people are sort of not sure what to do. So it'd be interesting to see what their take on that would be. Obviously, you're saying billable hours and billable time is a focus.
Yeah. Well, that's one of the negative aspects that they've certainly focused on and said, it's certainly one of the causes or contributing factors to adding to depression and anxiety.
Okay, and I guess I'm not sure what the alternatives are, but I suppose the problem is where people are pressured to and monitored to constantly increase the firm's income through that. So I think, yeah, I've luckily never worked in that kind of context. The times that I've worked in the profession have been in the public sector and in prosecutions, which there's no pressure to go out and find more criminals in prosecutions, which is fantastic. And most of my other work has been in community legal centres where you, of course, aren't billing anyone for the time. So I don't know that, I mean, it's a difficult balance, I think, because at some point, if you're making a living out of what you're doing, you need to be able to bill the client for what you do. And some things now, of course, people are increasingly looking at fixed costs for things. That was just like unheard of in my day. The idea you would say to someone, we will do a will or a conveyance for you and it'll cost this amount of money. I think when I studied legal ethics, that probably would have been considered unethical for mysterious reasons, more for sort of restraint of trade, I think, than anything else. So some of those things are changing. And I think, where people are really suffering is where people are saying, you've dropped below the average for the billable hours you're accruing. You need to work harder, longer, and I guess upsell clients too. I suspect there's a bit of pressure to say, while the client's in for this, also it's the gap upselling approach. Would you like fries with that approach? Sure, you're in here for a commercial contract, but can we do you a prenuptial agreement at the same time? And would you like, like to sue your neighbours while you're at it? That sort of, not that silly, but trying to, I guess, exploit clients and make more business out of clients. I know it happens in banking. I know in terms of a parallel profession, banking has had a major lambasting over the global financial crisis and the debts that people had accrued. And yet there's still people in banking have sales targets, and they're told to go into small businesses and make them borrow more money, encourage them to borrow more money, and at the same time they're told, oh, you have to be responsible, and we can't have another global financial crisis, and we can't be seen to be causing this, but we'll give you sales targets, and you have to meet those sales targets, or you're going to be out, or you're not going to get bonuses and that sort of thing. So I think that it's an evolving area, and I think finding new ways to appropriately bill clients and to run your business in a way that doesn't burn your staff out is not only an ethical issue, but it's also a common sense issue. Deloitte did some research recently, but I think they said it costs on average, and this is across businesses, something like $75,000 to replace a staff member of any note, because not only you've got the costs of advertising, and I mean not just all the costs and the time involved in advertising, but the severe cost of loss of institutional knowledge. So, I mean, Deloitte's are saying you're killing your own business by driving your staff too hard and having them leave, because basically you've then got to start from scratch and train someone new. And it takes another 2 years to do that. And if you've burnt them out in 2 years and they've gone somewhere else, you're just continually getting further and further behind. So I think maybe part of this is to convince people who are managing firms, and to give people who are managing firms more managerial skills, that burning people out is an ethical problem, but it is also a financial problem, because all you're doing is diminishing your firm's ability to make money. So if we want to be totally ruthlessly selfish about it, being nice to people actually makes sense. and being nasty to people doesn't. The other thing that's changing massively is Gen Y employees are shaping the workplace up, because they're not. Some of you guys are in this category, some in the generational group, but managers are finding hard to deal with the fact that Gen Y employees don't sit around and take abuse for years on the hollow promises that one day they will be able to climb the ladder. And in the legal profession, it's long been a stick to say, back in the days when you had article clerks, you basically worked as an indentured slave for a couple of years, and then you started out as a junior, and then one day you'd work your way up to being a senior partner. That hasn't been in operation for about 20 years. That system hasn't been working. And one of the things that's confounding firm managers is that Generation Y seem to know that. And they say, oh, well, if you work really, really hard at this terrible job, one day you will have this. And they say, I don't think so. And then they go and move and take a job somewhere else. So again, that is going to, in some ways, force firms to reevaluate some of their staffing practices, because they're not going to be able to keep staff. And they're not going to be able to keep staff with hollow promises that, one day it's all going to be well.
Yeah, on the flip side of that, Scott, is there's a massive oversupply of graduates coming out every year. True. So, yeah, universities have now become a business where once upon a time that there was quotas and things like that, and since it's a major part of the economy now, they're not going to regulate the numbers coming out, and you've just got massive oversupply issues where they'll be exploited by firms. They'll take advantage of that where they can.
Yeah, that's true. I guess the argument I'm making is that firms are also losing money through exploiting people, because they're employing people and they're leaving and they're having to employ new people. And some of them aren't seeing that, and they're just burning through and exploiting people and thinking that they're getting ahead. But at some point, hopefully, they'll figure out that it's better to actually pick the right people and to treat them well. But yeah, there is an oversupply, and we're not really in a position to complain much about that, because as one of sort of the youngest, newest law schools, we're sort of the last in, and we can't really say, well, they probably should just close Deakin Law School down, and whatever, because we'd be the ones that people would be blaming for the oversupply. One of my missions, actually, as part of the school, is to broaden horizons somewhat in terms of what fields legal graduates go into, and to build those connections. So my background's really in law reform, and a lot of people end up on various sides of the fence in the law reform area, not just working for government, but working as advocates, working for organisations that lobby for change. And that's one area of law that is almost never discussed. And I think it's an immensely rewarding and not immensely financially rewarding, but nothing is. It's a very interesting area of practice. So yeah, I don't want to be doom and gloom about this stuff. On the one side, there's the stats that show how few law places there are in the legal profession. However, the student destination surveys show that law graduates are very employed. So we need to start asking the questions more forcefully. Where are they being employed? Who's employing them? What are they doing? Hopefully they're not all working in JB Hi-Fi. Hopefully they're doing all sorts of interesting things, and that the legal, the law, and there's this, I'm going to go completely off the topic here, but some people talk about law being the new generalist degree, and it's basically law is the new arts degree. And I wouldn't say it's a generalist degree, because I don't think that's right. But you think of the skills you get from being a lawyer in terms of problem solving, analysing documentation, looking at change, how change is implemented, dealing with conflict, being able to weigh up sides of a conflict, deal with people. Like, all those skills are immensely useful in lots of different contexts. So again, tying this back, elliptically to the theme of tonight, I think we also have to be very focused on the fact that you don't have to be a success in the legal profession to be a success as a law graduate. There's lots of places that you can be and be, quite. I mean, my family still think, they say, oh, you're an associate professor now and you're a deputy dean, but when you're going to go back and practice law? I'm not going to now. But you have to also deal with those sort of the disappointment of people around you if you pick something else to do as well. And there's an awful lot of comedians who are lawyers as well, people like Sean McCaleb, at worst with a background in management. My degree form was as my experience. Yeah, I think we can do things a lot better. We can always do things a lot better, but I think a law, we often don't talk enough about the good things, about the skills we have as lawyers and as advocates. And I'm not diminishing anyone who wants to work in the profession either. I'm not sort of saying, oh, look, we don't care about the profession anymore because they don't employ many people. If that's your thing and that's what you want to do, yeah, do it, go for it. I mean, particularly in regional areas, there's a real need for people to have those skills. But let's look at the whole spectrum of what people do. Anyway, I don't know if I'm going to say it anyway. We look like the Rockhampton Community Legal Centre looks like is going to come on track next year, and we own the operation now, and we're looking at setting up a community legal centre network, not just out of people physically at the campus, but people being able to work from wherever you are within that practice. So good things are coming up in terms of our program and our curriculum, and we're going to look more at. We've had some time to get the first run of students through the degree. We're going to look at other options of things to actually value add and to look at those kinds of experiences we can use to build on these things. So. There are more good things coming, and keep your options open. So I'm conscious of the fact that we're sort of heading towards the last bit of time. Any further questions or comments on the issue? I know I've done a lot of talking tonight, but I do a lot of talking every night, and I should try and make sure everyone gets more of a chance to have their say. Next time, what are we doing? We're doing ambiguous wills next time. So this one's, have a read of it beforehand. It's going to require a little bit of preparation. We're probably not going to run through it quite. The way it's written is for small groups. It's for a much larger class than this. So we'll probably do it as a small group. But the task for next week is to think about what sort of wills could be ambiguous, that could be read multiple ways, that could create trouble. And of course, your best source of ideas for this will be the cases that are in the textbook, because they give you examples of things that have been ambiguous in the past. But use them as a starting point, and to try and think of and come up with ideas for next week for situations where you think the wording in a will might be ambiguous. The classic one. Again, I doubt if it ever happened in practice, where someone leaves their house to their son John and they have two sons called John. Real case, crazy as. I think in the 19th century there was only a limited number of names available, and someone had two sons called John. Now, how might that be ambiguous? What sort of other examples of that might be more likely to be ambiguous today? And that will be situations where it's not clear. Well, I won't try and preempt. Give you a week to sort of think about that and to think through some of those scenarios, because the legislation gives us a lot of power to fix up uncertainty and ambiguity in wills, but doesn't tell you what kind of uncertainty or what kind of ambiguity. So we're flipping the question around now, and I'm asking you guys to think about what sort of things might be ambiguous or uncertain. And we'll talk about those next week. So aside from that, are we all pushing along quite happily.
Just with the ambiguity, Scott,
Yeah.
are you talking more so where you apply to the court for the true construction of a will because of the ambiguity?
Yeah, or you're applying for the statutory powers to fix the will, or any. There's a few different options in there, but
Okay.
what we're thinking about is in what times can you write something that will be ambiguous, and sometimes it won't look ambiguous on the face of it.
Yep.
But when you come to apply it, so you say I leave my house in Lismore to Jane, and you've got 2 houses in Lismore.
Yep. Okay. I was just thinking I might have a good example I might be able to bring along to next week of a suicide note that we had to get admitted to probate that had a bit of ambiguity in it. So, but I'll have a look into it.
Yeah. Just take off any of the identifiers.
Yeah, no, I won't. I'll just
I'm sure
bring in some facts, that's all.
yeah, you bring the facts in. Okay, so that'll be cool, and that'll be, I think that'll be our last one before Christmas. So, I'll also make a little bit of time next week if people want to talk about the assessment at all. I'm presuming people are happy. No one's been asking me questions about the assessment. A few people have been putting in quizzes so far and been processing them. So, as far as I know,
I just had a question. I was going to ask you a question about the assignment, actually, Scott.
Yeah, sure.
I've just sort of been plodding away on it. Are you sort of looking at it? It seems to me it's more of a you're looking for more of a practical sort of assignment rather than a theoretical one. Is that would I be on track there?
Yeah, definitely.
So sort of looking at the potential problems out there, dealing with what sort of the aspect of the different culture and how that reflects with the law and the issues that you'll have with it, and the any ethical problems or that that you can identify.
Yep. And part of it is the sort of the equality before the law approach that we take is just to assume everyone's English, and there may be things that look fine when we talk about it, but then you find there are cultural differences that create a problem. So yeah, it's definitely you're gonna need to sort of have some cases and probably more sections of legislation. There's going to have to be stuff in there, but the way I would approach it is to think about if you had a practice that was servicing that particular community, and you were writing a guide for your colleagues and for new staff members to say, these are some issues to look out for. That's the genre I'm looking for. Does that make sense? Yeah,
that's okay. I've actually got some information from like a person, a fellow student that is from an ethnic background. So I don't know if I can use that or how I use it or reference it or.
You could do a case study or a narrative. We're going outside of, I know you probably your comfort zone in terms of research methodology, but you could do like a small narrative about, and you could use a false name for the person, but you could say, here is someone, here's a short example of a situation as like an example case study, and then analyse that. So that would be one way you would do it. You would need to reference it.
Yeah, okay. Yeah.
It's the kind of thing that sort of anthropologists and things do all the time. They go and talk to someone in a community and they get them to tell them their story, and they write it down, and then you can sort of use extracts from the story or retelling of the story. If you are feeling nervous about it, show me, and I'll give you some feedback on it. We've got a really small number of students in this subject, so we might as well take advantage of that. There was 120, I couldn't. I'm quite happy to do it with a small group like this.
Fair enough. Thanks for that.
Okay. Well, it's 8 o'clock. It's 8 o'clock here. If we've got no further questions, I will say good night to you all and see you all next week.
Thanks, Scott.
Bye.